This segment covers the ways that mediators can help to prepare self-represented litigants for mediation in those instances where the mediator has the opportunity to meet or speak with the participants before the mediation. This also covers how mediators can help parties better understand the merits of their case through evaluation. In this segment, we explore the benefits and best practices for conducting a pre-mediation meeting. In many court-connected mediation programs, pre-mediation discussions are not possible because the mediations are conducted the day of trial. However, when possible, they can provide significant assistance to self-represented litigants. What is a pre-mediation meeting or contact? A pre-mediation meeting or contact is between the mediator and each party and/or their attorney that is separate, that occurs before the joint session and is an attempt to improve the party's decision-making process. It can occur several days before the mediation or several hours before the mediation, but the preference is for it to occur about a week before the mediation, and we'll see why in a few minutes. It can be conducted in person or by telephone or Skype. One of the great advantages of pre-mediation meetings is to help the self-represented litigant plan. Let me explain. Much of the work a mediator can do in the mediation can be done better in a pre-mediation meeting. The information that a mediator shares during the pre-mediation meeting, for instance, is usually shared during the mediator's opening. The content is nearly identical. The other information that a mediator can uncover in a separate meeting can be uncovered in the separate meetings during the regular mediation. What's different about the pre-mediation meeting is time, having time. Doing the work in advance can be a way for the mediator and the self-represented litigant to reflect on the information and to plan the strategy for the mediation session more effectively. Some mediators use pre-mediation questionnaires. These are questions that the mediator will send in advance of the mediation or the joint session mediation. Parties will fill them out and send them back to the mediator. Pre-mediation questions include: list your basic concerns and the order of importance to you. What are the other side's concerns and their importance to them? What significant things do you agree about? Where do you disagree most strongly?
Let's hear briefly from mediator Ron Kelly to see how he uses pre-mediation questionnaires in his practice.
I do a lot of preparation beforehand. I have people fill out the answers to a set of 20 questions, and I have the disputants themselves do that personally. If they have counsel, and maybe 2/3 of my cases there is counsel involved, then they send it to counsel for any review, and well, we're not going to tell the mediator that. What are you, nuts? But the questions get at a very much larger range than just what are the facts and what are the law. They get at questions like, when did your relationship go south? When did that trust you place in each other first turn into a sense of betrayal or lack of confidence? What are your interests actually? If they did what you're asking them to do, what would that do for you? And if you have 4 or 5 different interests, which is most important and which is least, if you rank them, so that you know what you really need to get out of this and what other things you'd like but you can trade away if you have to. There's a whole set of different things. What could they do that would really push your buttons all over again when we get face-to-face, and how are you going to prepare yourself to handle that? Those kinds of questions. So I do a lot of preparation with people.
Let's look at the common tasks that a mediator might try to accomplish in a pre-mediation meeting. Educate the self-represented litigant about the mediation process, build rapport, learn about the dispute, learn about the parties, begin to explore important interests and options for resolution, shift the party's perspective on the problem, identify relevant documents, and, if appropriate, recommend the self-represented litigant to seek expert advice. Not all of these tasks are relevant all the time, and sometimes you might try to do even more sophisticated tasks like problem solving, but these are the common ones. Let's explore them each in turn.
Educating self-represented litigants. A pre-mediation meeting can be especially helpful to self-represented litigants as a way to familiarize them with the mediation process, the role of the mediator, and his or her role in the mediation. It's also done outside of the pressure of having parties waiting in the other room or a day of trial looming upon you. mediators can take more time with self-represented litigants in the pre-mediation meeting than they usually can when the day of trial mediation is scheduled, and can tailor the remarks specifically to the self-represented litigant's particular needs. This increases the chances of the self-represented litigant arriving at the mediation ready from the start to participate meaningfully and comfortably in the process. Building rapport. In addition to educating the self-represented litigant about the mediation process, pre-mediation meetings can also provide an excellent opportunity for a mediator to build rapport, something that is so important to the success of a mediation. If the mediator has done their job well during the pre-mediation conference, they will be able to start the mediation with a degree of trust and rapport that contact confers. And finally, the greater degree of trust a party has in a mediator, the more control and influence the mediator will have over the process, and the greater the assistance they can provide to the self-represented litigant. Learning about the dispute. Mediators can learn about the dispute in a low-pressure setting when parties may be more comfortable and willing to share information that might help to settle the dispute. Although parties sometimes file mediation briefs, rarely will those briefs reveal anything about a party's underlying interest or true negotiating position. These documents usually consist of facts and legal arguments that can be helpful, but are insufficient to settle the matter. Learning about the parties. Pre-mediation meetings give mediators the opportunity to assess the personality of the parties. This is often critical to a mediation success. Knowing this in advance allows a mediator to prepare strategies for addressing these concerns or addressing them before the first mediation meeting. So, for example, some of the things that you could know much more about before you went into the joint session mediation are: what is their conflict style? Will they likely be civil and respectful to the other party? Are emotions such as anger or fear likely to play a significant role in the mediation and help to develop strategies to deal with those things? Are they flexible about possible solutions? Are they mentally competent to meaningfully participate in the mediation? Explore options for resolution. A pre-mediation meeting is also an excellent opportunity to explore the self-represented litigant's priorities and possible solutions. Exploring these options before the actual mediation provides the self-represented litigants time to think about the solution before the mediation. This also provides self-represented litigants time to check to see if the solution is workable by gathering relevant information, or consulting with experts, or consulting with family and friends.
The pre-mediation meeting is often a very helpful place to start the process of shifting the party's perspective on the problem. Self-represented litigants often come into the mediation with a very concrete idea about why the problem exists. Remember, no matter how sophisticated or intelligent a self-represented litigant may be, they are not a trained lawyer, and lawyers are trained to see both sides of the problem. Questions are often a very helpful way to begin the process of perspective shifting. So you might ask the self-represented litigant why the other side is taking the position they're taking, or how do you think that the other side is responding to this fact or responding to this behavior? And again, it's not judging any of it. It's simply trying to get the self-represented litigant to place themselves in the other party's shoes, to sort of see the world from that perspective, at least for a little bit. Once the party starts to at least acknowledge some of the other side's concerns, even if they don't agree with them fully, it helps the mediation process. It helps to begin to carve out a place where compromise or collaboration can begin.
Identifying documents and other tangible evidence. Because self-represented litigants are often unfamiliar with the law and legal procedures, they often need assistance in identifying documents and other relevant forms of evidence necessary to participate effectively in the mediation. When these relevant documents are not available at mediation, either the mediation will need to be adjourned, or the self-represented litigant will need to make less informed decisions about settlement. Neither circumstance is ideal. Relevant documents and evidence can be identified at the pre-mediation meeting, and, if necessary, there is time to locate or obtain them if they are in control of a third party. Referring self-represented litigants to experts. Mediators have the ability to refer the self-represented litigant to other experts that he or she believes would be helpful in preparing the self-represented litigant for mediation. Let's look at the relevant California rule. And I quote, "A mediator may recommend the use of other services in connection with the mediation and may recommend particular providers of other services. However, a mediator must disclose any related personal or financial interest if recommending the services of specific individuals or organizations." Examples of the type of experts to whom self-represented litigants may be referred. So here are some common experts that you may feel, as the mediator, the self-represented litigant, should consult with prior to the joint session. Lawyers, to get legal advice, accountants for financial advice, physicians for advice dealing with some of the medical issues that may be relevant in the mediation, and just any other subject matter expert that seems that would be helpful. Legal advice and support. Because self-represented litigants often cannot afford legal representation, mediators should be familiar with the array of support services that California makes available to self-represented litigants in your jurisdiction. Mediators can refer self-represented litigants to the following when appropriate. Here are some websites.
The first link on your screen is to the California Self-Help webpage. And this webpage has a variety of information divided by type of case, like adoption or child custody, child support, debt collection, and also process information about how small claims work versus going to a guardianship court. The third link on your screen is a link to videos that show information about resolving small claims, unlawful detainer, civil harassment, debt collection, and additional kinds of civil procedure processes that will help litigants understand the court system better. The fourth link on your screen is information about ADR, and it includes videos on mediation and explanations of the differences in the various dispute resolution processes. Now let's watch some excerpts from a couple of different pre-mediation conferences that Pauline conducted. We can assume that she's already explained the mediation process to the defendant in a similar way that she might explain it in an opening statement. Here, she's emphasizing three ideas. First, she's trying to find out the story, learn about the problem. Second, she's going to do some perspective shifting. She's going to try to get the tenant to see the situation from the landlord's perspective, and then she's going to do some brainstorming, helping the party get some ideas about what are some ways to solve the problem.
I've been a tenant at an apartment complex for about 2 years now, where Carla Robertson has been my landlord. And I'm here today because I'm really confused. I've received 2 3-day notices, and one of them, I believe, was to pay or quit, and another was to perform or quit, something like that. I think I remember. And I feel really confused because I've never been, bad at paying rent. She gets the rent every month. I always pay. There's not a problem there. I may be a little late sometimes, and I understand, but I do give her a call. I always let her know when this is going to happen or when this is the case for me. Mm-hmm. She's always really understanding. Mm-hmm. She's never had any comments about my 2 dogs, Frankie and Jessie, whom I've had since they were puppies, and we all moved in together. I consider them my children, mm-hmm. really. I live alone, and so they're my companions, and they really are my children. Mm-hmm. And she didn't have a problem with this. And now, 2 years later, all of a sudden, I received these notices. And all I can think of is the last time I spoke with her, I asked her to make some repairs mm-hmm. in the apartment. For example, my sink is broken. It only has cold water, so that can be pretty chilly in the winter. Mm-hmm. Also, my bathroom has mold. There's flies and bugs coming from under the tub. And that's really disturbing to me because mm-hmm. I do pay a fair amount of rent each month, and I shouldn't have to deal with these issues. Also, my oven is broken. The seal doesn't work, so I can't use it. Mm-hmm. So really I have the stovetop and the microwave, and that's also bothersome to me.
Mm-hmm. So just so that I make sure I've heard you correctly so far, and I'll invite you to add anything that you may have not added yet or wanted to clarify after I let you know what I've heard so far. You've been at this property for about 2 years or so, and Carla's been the landlord this whole time. Is that correct?
Yes.
From what you've said, you've had a good working relationship with Carla so far, in terms of being able to pay your rent. You get the rent in every month, even though it might be a little late. You mentioned that Carla's been very understanding of your situation, but you've also worked with her to let her know in advance when that's going to be the situation of getting rent in late.
Right.
You also mentioned that there are 2 dogs that live with you, Frankie and Jessie, whom you love and call your children, and you brought them in when you also moved in, and they were puppies at the time, and Carla hadn't mentioned any concerns or issues with them prior to fairly recently. Is that correct?
Right, exactly.
Now, all of these concerns, while no one concern is more important than the other, what would you like to spend today's session trying to brainstorm ideas on how to move forward with the situation, hopefully to avoid court? And so what are your priorities? What are some of the things you'd like to start talking about today?
Well, I really love living where I'm at.
Mm-hmm.
I really appreciate a landlord like Carla. She's been really understanding, and I consider her a friend.
Mm-hmm.
And she's been great. I just feel really confused. I feel like it's an unfortunate situation that as soon as I ask for these repairs, I get a notice to remove my children
Mm-hmm.
from the apartment.
Mm-hmm.
And so my concern is mainly my dogs.
Your dogs.
They're my children, and
Mm-hmm.
we need to stay together.
Mm-hmm. So I hear what you're saying. What I hear you saying is that your dogs are the priority for you to try to work something out so that you can keep the dogs and stay together, as you mentioned.
Absolutely.
Okay. So in working towards that possible outcome, I think it's helpful to think a little bit about what Carla's perspective is from her point of view. In terms of your dogs, tell me a little bit more about them. What breed are they? You mentioned they were pit bulls, or did you?
They're pit bulls.
They're pit bulls, okay.
Yes, I've had them since they were puppies,
Mm-hmm.
since we all moved in together 2 years ago.
Okay, and they get along with people. They're nice. They're friendly.
They're sweethearts.
They're sweethearts.
Yes.
Okay.
I took them to obedience school. They
Mm-hmm.
graduated. They
Mm-hmm.
both have certificates. They've been great. Absolutely wonderful.
Yeah, I can see you're very proud of
I am.
them. Yeah. So, where can you see at all why Carla might have given you these notices for the dogs and asking you to find another home for them? Can you imagine any reason why she might ask you to do that after all this time?
To be honest, I think it's just so close in time to the time that I asked her for repairs to my
Mm-hmm.
apartment. I understand that my dogs are pit bulls and there's this terrible stigma about them, but
Mm-hmm.
my dogs are nothing like that. They're sweethearts, and because I do live alone, they're a little protective in the sense that
Mm-hmm.
they'll let me know when someone's at the door,
Mm-hmm.
and because they're used to barking a little bit when someone is at the door, they may even do it when I'm not home.
Mm-hmm.
I'm not sure, but they're in no way dangerous or deadly to anyone.
Okay, but you did mention barking as your dog's response to maybe having someone at the door that they're not familiar with,
They do.
things like that. Is it possible that their barking might scare people or, cause people to be concerned about safety, anything like that?
Well, I think because they're not golden retrievers barking, for example,
Mm-hmm.
because they are pit bulls, there may be this stigma that because they're barking, they're going to be, outrageously dangerous or ferocious.
Mm-hmm. Mm-hmm. Could you see how Carla might take some of the things she's heard from the news or stories that she's heard and be concerned about the unpredictable nature of how a pit bull might react if they get triggered a certain way? Can you see how she might be concerned about something like that?
I mean, she's known my dogs since they were puppies, babies, but I can see how some of that might affect her.
Mm-hmm. And what do you think, from her perspective, that concern will lead to. Kind of why is that concern important for her? Why do you think that having that fear is something that's kind of driving her decision to maybe asking you to get rid of the dogs at this point?
Well, I guess I can imagine she's worried because we live in a complex that maybe other people might get hurt.
So perhaps this idea of safety or providing a safe environment for other people to live in, even though you may not agree that your dogs are dangerous or will ever do that, perhaps her concern is that because she doesn't know for sure, it might be something that she's thinking about in terms of your dogs.
It's possible.
It's possible. Keeping that in mind, and again, this exercise was to try to have both of you put yourselves in each other's position, because moving forward at the mediation down the line that we're going to have in a couple of days, in order to have an agreement, it's going to need to address your needs and her needs and concerns as well. So being able to think about this now will be helpful to craft a solution that might be workable. Now, have you thought, knowing that safety might be a concern of hers and possibly the liability perhaps that she may be thinking about that she might incur if the dogs bite someone or injures someone, what are some possible things that you can do or have thought about doing to maybe help calm some of her fears?
Let's watch Pauline help the self-represented litigant generate and see some additional solutions to her problem.
Why don't we spend just a couple minutes together and talk through what are some possible things that could be in your future in terms of the situation. So what are some things that you think might be on the table at this point?
I did bring some notes with me today about insurance plans, pet insurance. So I looked through some of the plans, I did some research, and it seems like this may be workable for me. I may be able to afford, because they're pit bulls, the plans are a little more expensive, so they range from $50 to $100 a month. I may be able to do the $50 a month, and that covers up to $50,000 in damage.
I see. Great.
And I thought about the possibility of moving.
Okay.
Although it's not something I necessarily want to do. I'm comfortable where I'm at, but it's a possibility.
Sure. Yeah, we don't have to make a decision now about whether something's workable or not workable. We're just trying to get as many ideas or as many possible outcomes out there as possible so we can take a look at the bigger picture, the full picture, and to see if there's a way to make sure that no idea gets left unthought about or not thought about. Okay?
Okay.
So moving, you mentioned, is something that you've thought about but you don't prefer to do.
Right.
Going to court is something that's still kind of hanging out there as of this point in time. What are your thoughts on, and have you ever had an experience with paying a pet deposit either for these dogs or any other pets before at any other place?
Yes. Moving in, I paid $300 per dog.
$300 per dog.
So yes,
okay.
so I did pay a pet deposit.
Okay, so just to make sure my math is correct, so you put down $600 when you first moved in.
That's correct.
Okay.
In these last two vignettes, Pauline was accomplishing three important mediator tasks. First, she's determining the problem. Second, she's trying to shift perspective. And third, she's brainstorming. Of course, mediators should try to accomplish these tasks in the mediation proper, but performing them in a pre-mediation meeting, when available, has its advantages. One advantage is time. Typically, you'll have more time to explore these different tasks in a pre-mediation meeting than you will in a mediation proper when there are all the parties present, and oftentimes these kinds of tasks, like perspective shifting, for example, is done when the other party is waiting and you're in a separate meeting. The second advantage is that you will have done a lot of this work in a pre-mediation meeting and therefore continue the work in the mediation proper. And so oftentimes the litigant has more time to have thought about their story, their perspective, and brainstorming ideas in the mediation proper because you've already started that excellent work in the pre-mediation meeting. Now let's talk briefly about some of the things that Pauline did in particular for each of these three tasks. With regard to determining the problem, there were three things that Pauline did here that most mediators do to help the process move forward. One is listening, giving the litigant enough space simply to tell their story. Two is summarizing to make sure you understand. And in this case, Pauline was using very key words that repeated the words that the litigant used. For example, she talked about the dogs as her children. And when Pauline summarized, Pauline said, you consider these dogs your children. And then finally, priority, helping to prioritize the many issues that the litigant will talk about. And so the litigant talked about mold and other problems with the apartment. But in the end, she cared most about the dog. So it's important to prioritize the issues that you hear. Second, Pauline tried to shift the litigant's perspective. One of the big problems with conflict is that we get into our own heads and see the world only from our own vantage point. And in problem solving, we need to expand that vantage point to include the other party's perspective, whether we agree with that perspective or not. So here, Pauline asked several perspective shifting questions. For example, she said, is it possible that the barking could cause concerns? Could you see how Carla could be concerned? And then started to tease out some of those potential concerns. These are very useful questions to help expand the perspective of the litigant. And thirdly, Pauline talked about brainstorming in that second vignette. And here she was simply trying to get the self-represented litigant to think a little bit more broadly about some of the solutions. And so she got out the concerns first and then led the litigant to potential solutions, not necessarily worrying a lot about whether they're workable, but simply just getting them on the table for discussion with the other side.
Let's summarize this section. The pre-mediation meeting is not always available in court-connected mediations, but you should avail yourself to it when it is. Mediators can educate the self-represented litigant, build rapport, learn about the dispute and the parties, identify relevant evidence, refer self-represented litigants to experts, and explore the acceptability of settlement options. Accomplishing these tasks before the mediation allows self-represented litigants to enter the process better prepared. Also, it enables the mediator to enter the mediation with a greater understanding of the potential obstacles to settlement and a strategy to overcome those obstacles. And this makes for a much more effective mediation process. I remember when I was starting out my mediation practice, when the books that I read said you should prepare for the mediation and prepare strategies, and I didn't know what they meant, because while I could understand the law, oftentimes in mediations that were court-connected, you knew very little about the dispute prior to actually being in the room. And so not knowing much about the dispute, what kind of strategies could you develop? Now think about this. You've had separate meetings with both of the parties, some of them lasting an hour or more long. Now, knowing the issues in the case, knowing the facts of the case, knowing the personalities in the room, knowing their willingness to be flexible, you can develop very meaningful strategies to help make the mediation success, and in particular, help self-represented litigants participate as meaningfully as possible.
You will now be directed to a short quiz to assess your understanding of the information just presented.